Good afternoon, my name is Vasily Tarasenko and I'm a Russian lawyer. One of the most frequent questions asked to our lawyers are questions about dissolution of an international marriage in Russia. Today I will try to answer the questions that our clients previously had in divorce cases as fully as possible. Let's get it started. So let's go according to the plan. First, ways to dissolve a marriage through the court and without a court decision. Second, what documents you need for divorce without the court. Third, is it possible to dissolve a marriage without one of the spouses participating? Number 4, how to dissolve a marriage in Russia through the court. Action plan. Number 5, is it possible to dissolve a marriage in Russia that one entered not in Russia but in another state? 6. What documents are needed and how to prepare them for filing to the court? Number 7. In which court in Russia should I apply for divorce? Number 8. What to do with the court decision? So, how to dissolve a marriage in Russia? The ways to dissolve the marriage are, first of them is through the registry office, ZAGS in Russia, and second one through the court. When a marriage can be dissolved without a court decision? First case, it's when both spouses agree to dissolve the marriage. Second is the couple has no children under the age of 18. And the third case is when spouses have adult children, but one of the spouses was sentenced for committing a crime to imprisonment for more than 3 years. In any of these cases, the spouses or one of spouses, when another one is in prison, apply to the ZAGS in person and a month later receive a divorce certificate. What documents are you need for divorce? First of them, it's an original of marriage certificate. Second is original of passport of spouses. Also personal statements and presence when applying to the registry office. Also state fee payment receipt. It's about 650 rubles from each spouse. Question 3. Is it possible to dissolve a marriage in the listed cases without one of the spouses participating? That is, without being in Russia. For example, when a foreign national cannot come to Russia. So the answer is yes, it is possible, in case of additional documents are provided. A spouse who cannot appear in person at the registry office for divorce must additionally provide some documents. It's a written notarized consent and application of the second party for the dissolution of the marriage. Also, power of attorney in the name of the second spouse to apply for divorce. These documents must be in Russian language, and if they are drawn up at another country, then they must be apostilled and translated into Russian language. I will tell you more about apostille and legalization later. So, after the documents are prepared, they just need to be sent by postal services to Russia, where the second spouse will receive them and submit them to the registry office along with other their documents. After 1 month, the marriage with a foreign national will be terminated. This is where we can finish the topic of dissolution of marriage without a trial. And now we will move on to the second part. It's dissolution of marriage in Russia through the court. So question number 4. How to dissolve a marriage in Russia through the court? Action plan. So first of all, you need to prepare an application for the court which must indicate address of the plaintiff and defendant, whatever the spouses have joint children and whatever there is a dispute about who they will live with after divorce, and whatever there is a property dispute. The divorce application must be accompanied by original marriage certificate, receipt of state duty payment, birth certificate of children, if any children exist, proof of residence of the defendant. Before filing a claim with the court, you must send a copy of it to the defendant without fail and attach the postal receipt to the claim filed with the court. Divorce procedure in the court, let's discuss it. After accepting the claim, the court notifies the parties about the date of the court session, and not earlier than after 1 month from the date of accepting the claim makes a decision on the dissolution of the marriage. If there are any objections from a spouse, the court may refuse to dissolve the marriage only in case of pregnancy, as well as if there is a minor children under the age of 1 year. In other cases, divorce is inevitable even if the second spouse doesn't grant their consent. And the spouse who doesn't agree to dissolve the marriage can only ask for time for reconciliation of no more than 3 months. If after this period spouse insists on dissolution of marriage, the court will inevitably make decision about the divorce. Is it possible to dissolve a marriage in Russia that one entered in, not in Russia, but it's another state? So in our practice, we often come across cases when we need to dissolve a marriage entered into in a foreign state, or a marriage between a foreign national and a Russian one. I must say that right away that it is allowed to dissolve a marriage entered into in another country in a Russian court, since the court family code of the Russian Federation recognizes the validity of a marriage entered into another state. However, there are a number of specific details that complicate the process. Namely, the difficulty lies in the preparation of documentations. And its marriage certificate was issued by the competent authority of foreign state, and also marriage certificate is not in Russian language and the plaintiff doesn't live in Russia. So, what documents does a foreign national need and how to prepare them for filing with the court? So, first of all, marriage certificate issued in another country requires legalization or apostille. Without this, you cannot go to the court. Any documents that was obtained in a foreign state will be considered evidence in court only after the legalization. This requirement is specified in a civil procedural code. There are two types of legalization of foreign documents. First of them is a consular legalization, and the second one is apostille. The type of legalization required for you depends on in which country the documents was issued. So let's talk what is apostille. Apostille is a simplified type of legalization, which is the fixing of the apostille stamp on a document by the competent authority of the country that issued the document. The apostille confirms that it was drawn up in the country by the relevant authority or official. You need to apostille the documents that was issued in a country that has ratified the Hague Convention of October 5 of 1961. Consular legalization is a procedure for confirming the signature of the person who drew up the document, and if the document is stamped by an official body, then the procedure certifies the correctness of the seal. Consular legalization is a more complicated process than apostille, because consular legalization takes place in two stages. First stage is the documents are submitted by the applicant to the authorized consular office in the country where the document was made. Second stage is the document is legalized in the diplomatic mission of the country where the document was made in the state where you are going to apply this document. The marriage certificate must be translated into Russian language and authenticity of the translation notarized. Judicial proceedings in Russia are only in Russian. Of course, this doesn't deprive you of the right to submit documents in another language to the court. The only detail is that such documents must be translated. A document in a foreign language must be submitted to the court in a translated and notarized form. As a result of such translation and notarization, you receive a translation attached to the original marriage certificate and a notary stamp, which certifies that a translator made this translation. So question number 7, it's in which court do I file the divorce? So for example, if my spouse resides in Russia. So you should file a statement of claim with the magistrate court according to the last address known to you as the place of residence of your Russian spouse in Russia, or where the property of the foreign national is located. That is, if the spouse resides in the city of Kazan, then you need to apply to the Kazan court. After receiving the claim, the court, having sent the summons to the defendant and having received information about its delivery to the defendant, will decide on the dissolution of the marriage if it doesn't have information on a dispute about children. Number 8, what to do with the court decision on divorce. A month after the court made a decision about the divorce, you need to obtain this decision with the stamp on coming into legal force. After that, you should submit the court decision to the register office and receive a divorce certificate. On this, your marriage can be considered officially terminated. So, if you need help with the divorce cases, you can reach out to us for legal assistance. My name is Vasily Tarasenko. I am a Russian attorney. Subscribe please to our channel. I wish you good luck. Bye.